evening, chat. Hello. And is my window open? Oh, it's one of those nice nights where like the doors, we had like everything open tonight, and you just walk inside and out, like in and out of the house, and you didn't feel a change in temperature. It's kind of one of those nice nights. Not gonna have those too much longer because in Florida it's gonna be just like ball of humidity. Anyways, welcome to the show, everybody. Welcome to the show. My name is Sean, also known as Potentially Criminal. I am an attorney in the Cleveland, Ohio area, and tonight we're going to talk about, a lot of kind of interesting stuff. I guess we'll leave it at that. Interesting stuff. Is it hilarious? Some of it's kind of hilarious. Some of it's kind of important. Some of it's kind of interesting. But overall, I think it'll be a good night tonight. I think it will be a good night tonight. And where is... Okay, I'm going to move that and move this. Anyways, welcome. Hope you guys are doing well. We are live tonight on Kick, on Twitter, and last but not least, here on YouTube. Interesting stuff, as not opposed to the usual crap. Yeah. Yes. J-Rock says, Mudahar nuked Jeremy Hambley. Oh, did he saw him to death? That'll be good. Are we gonna body cams for once? No. Jeez. It's a good night for spiders. No, it's not. It's never a good night for spiders. Never a good night for spiders. And Chugi Show for $2 says late and reading all the betting statutes. Well, we're gonna get to that because that story, that's gonna be one we're gonna get to in a little bit. It's kind of, it's a little funny when you think about it. And we'll get to that in a little bit. We'll get to that in a little bit. But thank you for the super chat there, Chewy. Mudahar has 4 million subs. Yes. How was everybody's weekend? Yes. How was everyone's weekend? Oh, Jeremy's he's so fucked with all this. He's so screwed. I just don't understand how he thinks it's gonna go. I don't understand. I don't. But he thinks he's smart to do it. Justice says, hail, Sean. Hail, chat. Well, hi. Hello. Yes, it's spreading everywhere. It's spreading everywhere like a wildfire. A little Jen says, time for the song. Which song? Yes, I did see that. If you guys want to play that, yeah, we're not going to play that tonight. But that would be so funny. Yes, we do have some updates on some stuff here, you guys. This is going to be, I guess we'll start off with just a really quick HRO update news between the two gayest men in Minnesota. There is the dates were set for June 5th. Nick and Aaron, cock versus cock. And, it's like the song, two cucks collide, rival faggots. In a burning chair, there's some cucks to burst. Oh, that's what they're gonna do. But anyways, it's gonna be cuck on cuck violence on June 5th. Patrick Melton has been told though it's still being set for a settlement conference, so Melton's gonna have to fucking hop on a plane and fly the fuck out, and then get another date probably later. It's going to be very, very fun. It's going to be very fun. But we do have, and this was something that I saw this on the forums earlier. We're going to share it, chat. We're going to share this because I do think it's worth showing. And I didn't realize somebody had animated this or was animated up. But this is just phenomenal. You can't beat it. June 5th at the Sturds County Courthouse. You have cuck versus cock.
This is harassment. He's always mocking me.
Harassment? Really, Nick R? It do be like that, Mr. Nick R.
Your Honor, make him stop.
Please, this is comedy gold.
I mean, I don't think it's going to be like that. I think Nick thinks he's going to be able to talk about a bunch of stuff and win. And remember, Nick, he knows all about the statutes. He hasn't really ever shown anybody what's in the statutes, and he's read all the case law. He hasn't shown anybody the case law. It's like all those studies about the cocaine testing and why it was bad. He said he read all kinds of abstracts and read all the literature, but we never saw the literature. You know, and when it comes to the law, citation needed is like one of the foundational things. Citation needed. Just think about it, chat. Yes, that one Quora page. Yep. Yes. Misspelled Stearns. You know what? I didn't make it. It's the thought that counts. It's a thought that counts. Oh. Have you read it? Answer the question. I have read it. I have. He called you fat recently. I know he did. I know. Maybe he'll come up with something new. Yes, it's a cucks world out there. Did I see the yes, I did. Third World Aristocrat put that together. I think he gave it to Alyssa. But yes, it's the I gotta figure out a way to like weave that into an introduction. Just Sean. It's like Drex, like he's like Sean. All right, guys, let's go. He's persistent on the fan angle. Either he had like a fat Boy Scout like leader touch him, or I don't know what happened. Like when he was little, did his pants fall down and a fat girl laugh at his like little wiener, or what? I don't know. Something happened. Something happened where he's got this issue of fat people. I don't know what it is, but maybe he'll get over it at some point. But anyways, let's get to the show. Enough time wasting on these, you know, this cuckoldry. We don't have any time for it. Let's get to the first thing. And I think this one, well, it involves AI, chat. It involves AI. And this may not seem like a big deal. A bankruptcy case out in the Southern District of New York. Well, there was an AI issue. You're like, okay, well, that doesn't sound like that big a deal. And on its face, yeah, it doesn't sound like a big deal until you realize like what it is. And we're gonna wrong thing there. Until you realize what it's about here. And this is where things get interesting. And we'll start off by just addressing what this case is about real quick. And it's funny, kind of like in a ha-ha, not really funny at all fucking way. It's actually really rather fucking infuriating, especially as a solo practitioner in a small firm, you know, being myself. So this is to the Honorable Judge Glenn, the U.S. Bankruptcy Court, the Southern District of New York. Now, what is this? Well, it's a place called Prince Global Holdings Limited. I think it's in Prince, like it was like Michael Prince Capital is one of the bad guys in Billions. But it's like this is not like just fucking Bob Smith going bankrupt. This is not Bob Smith going bankrupt here. Okay. So what do they say? Dear Chief Judge Glenn, Sullivan Cromwell, LLP, the firm represents the joint provisional liquidators on the above referenced matter. And that's something that happens in a bankruptcy case. You'll have liquidations. And notice the person writing says, I became aware Thursday evening that the emergency motion for entry of orders granting ex parte relief, a provisional relief, included inaccurate citations and other errors. These inaccuracies and errors included artificial intelligence hallucinations. And then hallucinations are instances in which AI or LLMs, large language models, fabricate case citations. And not only case citations, chat, there are times where people have said, okay, give me the holding from that case. And the AI just hallucinates an entire case holding with more fake citations. Like it's a real problem. It's a real problem. They misquote authorities or generate non-existent legal sources. Yeah. We deeply regret that this has occurred. The firm maintains comprehensive policies and training requirements governing the use of AI tools in legal work. Those safeguards are designed to prevent the situation. And we'll get to why that's kind of a big deal here. The firm's policies on the use of AI were not followed in connection with the preparation. In addition, the firm has general policies and training requirements for the proper review of legal citations. Apparently, it didn't work here. Regrettably, this review process did not identify the inaccurate citations nor did it identify other errors that appear to have resulted in whole or in part from manual error. The firm has undertaken immediate remedial measures, but not limited to a full review of circumstances leading these errors and a re-review of all filings in this matter. We can confirm that the other filings do not include any AI-related errors. Our re-review did not identify non-substantive and or clerical errors in other filings in this matter. And they talk about here that we do not believe, we did identify other errors, but we don't believe those are the result of AI. And you know what? Everybody makes a typo. Okay. Their errors are also identified. We are keenly aware of our responsibility to ensure the accuracy of all submissions under the local bankruptcy rules, and you do. He says, I want to assure the court the firm's policies governing AI are both clear and rigorous. Well, it didn't help. AI tools are conditioned on completion of mandatory training. Before any firm lawyer is granted access to AI tools, the lawyer must complete 2 required modules, completion of which is tracked and verified. And the training repeatedly emphasizes the risk of AI hallucinations and fabrication of citations. It instructs lawyers to trust nothing and verify everything. It makes clear the failure to independently verify things constitutes a violation of firm policy. That sounds pretty serious. This sounds pretty serious for these guys. And some of you guys are asking the questions I want to ask. These requirements are reinforced in the firm's office manual for lawyers. Lawyers must independently check all answers, citations, and information work product received from an AI program for both substantive and non-substantive accuracy. And it goes on and on and on. But this is by a firm also known as Sullivan Cromwell. Yeah. You guys, you may not have heard of them, but when you go by, these guys are no slouches because they're pretty important. You're like, well, how big are they really? This is as of 2021. They were the 4th highest based on the profits per equity partner. Meaning each equity partner in 2021 got $6.36 million. They were the 4th highest paying out firm in the world. Up there with Kirkland Ellis. Another ones you've ever heard of. Latham and Watkins. One that did all the work for Hunter Biden. Quinn Emanuel, Urquhart, and Sullivan. That's where Alec Baldwin's attorney, is. Then you see other ones on here like Skadden and Arps. Paul Hastings. These are, Gibson, Dunn and Crutcher. These are big-time law firms, chat. Big-time law firms. Even like White and Case. These firms are huge. These firms are huge. And as of 2025, actually, I did some digging. Sullivan and Cromwell is still number 4, but they're now up to $6.7 million a year per equity partner, which means probably Davis Polk, Kirkland Ellis, and Wachtel is probably even higher than $8.4 million. Just think about that. So these guys, this isn't like Joe Schmo, the strip mall lawyer. No, one of the biggest law firms in the world. You work for these guys. If you work for Sullivan and Cromwell, that's like playing for the Yankees. That's up there. That's up there with the big timers, guys. That is up there. Look at all these names. If you guys have probably heard a bunch of these names at one point or another. These are huge freaking law firms. DLA Piper. That's where oh God, what's his name from the Karen Reed trial? The smart guy. That's Kirkland and Ellis are not the Costco lawyers. Stop. Yeah, Alessi. Alessi is the head of litigation at DLA Piper. I mean, these are massive law firms, chat. Like Perkins Coie. They were, a lot of Democrat hatchet man work. Squire Patton Boggs. Another big one. These are no slouches. All these firms here. And these guys getting paid $2,000 an hour. $2,000, $3,000 an hour for their partners. You start playing around with ChatGPT. And the problem with them is, the partner, like you have the partner, and he's like probably $2,500 an hour, right? Okay, well, the partner's not doing all the work on that case. And there might be multiple partners on that case who bill for it. Okay. But then you have associates who are in partner track. And then you might have junior associates touching the case. You also might have attorneys who are non-partner track, which is a thing that's become more and more. I don't think Sullivan Cromwell probably done that. But there's quite a few places where you can be an attorney and you're not on the partner track. Your obligations to do billable hours and stuff are reduced, but you're also left out of that opportunity to get partner track. So you voluntarily clip your wings, but it allows you to actually have like a family life and not want to kill yourself. And from there, you have like paralegals. You have paralegals who are going to review stuff and touch it. And there are going to be multiple attorneys, junior associates, and multiple paralegals touching all of this stuff. So, well, yes, this was some sort of emergency motion. I have no doubt 10 to 15 people had access to it and touched it. 10 to 15 on a firm this big. 10 to 15 people probably touched it. And they did AI. And you might say, well, Sean, how do you know what thing it is? Well, it's been reported because Sullivan and Cromwell put out press releases like they were proud to have a ChatGPT license for like the high test ChatGPT. Like they were running the premium grade. And they were proud of it and they were training all their people on it. $2,500 fucking dollars an hour. And they're using ChatGPT. I still don't use it. You can't trust it. Do not use it. Like the biggest law firm in the world are using ChatGPT. Oh my God. Yeah. What are these guys really worth? More importantly, what are their malpractice firms going to do? Oh my God. Imagine when their AI, like their malpractice insurer does. This is an affront to everything. J-Rock Law says AI isn't meant for lawyering. It's a future of enterprise enterprise software, though. Yes, it's got uses. The law is not like the place where you have to actually do the art of bullshitting. AI can't hang. And we talked about this with other cases earlier. AI cannot work in this situation. And I just, these people, Sullivan and Cromwell, they would not, like, if I was graduating, University of Toledo, I could be number one at the University of Toledo. They ain't fucking reading my resume. They ain't coming out to Toledo do an on-campus interview. They aren't letting me be like a summer 3L. No. Like the people working there are going to be like top 20 law schools, if not even higher. And yet all these mooks still did this. I don't know, like, where is the justice in this world? Oh. Spuggun says, what is a 3L? Actually, so the way you're classified in law school in America is 3 years. If you go full time, it's 3 years. Some of us it took 5 years because we went part time the whole way through. Just saying. But you have different years. So your first year is called your 1L year. Your second year is your 2L. Your third year is your 3L year. And for a lot of these law firms, in between your 2L and 3L years, so that summer before your third year of law school, they'll take students on as like summer 3Ls is what they're called. Like, and they have summer programs. And if you do really well, it's kind of like a little bit of a mini tryout. And they use you as basically field hands. And yes, it's slavery. And the idea is that you would do well, you'll come back and they'll pay you to sit and get ready to take the bar and pass the bar. And then they'll have you running full tilt for them. So that's why it's 1L, 2L, 3L. For me, I basically did, it took me 5 years, but I also only did a half semester at a time. I was literally a night student the whole way through. So, yeah. C3 Middle Thingy says, can their clients that are pissed about this, can the clients go after them? If this hurt anybody, yes. But, I mean, I think that, they're going to have to start, like, if they were smart, they were talking to their clients. Do we need to give you a refund on any money? Do we need to cut billing? I don't know, but something, I mean, yeah. And most importantly, has anybody actually been fired for this? I mean, did anybody get fired for this? No one got fired along the way. These 10 to 15 people at minimum, probably even more who touched this. Was the partner fired? Was anybody fired? Probably not at this point. So, sadly, no. Pepsi Man says, where does Rekieta Law rank in this? I don't know where he ranks on there. I don't know where the Martin Law Office ranks on there anyway. We're going to be out of action for about a year, so it's going to take a hit on the partner equity rating. So, but anyways, Afton Ford for 10 subs. Thank you so much for your support. Thank you all for being here tonight. We got to get a woo in. We got to figure out a way to get Clyde to do another woo. But for right now, we got that. Law King says, will you cover David? Yes, that's actually going to be like the next thing. Actually, it'll be the next thing after the marijuana stuff. Well, we got some David stuff to go through. So I need to make some shorts, or I don't mean shorts, chat, but I need to cut up my content a little bit, and we're going to try that here. Okay, so we're going to make some short things again like we were doing for a while. Danny Hardesty says, the first year you're scared to death, second year you're worked to death, and the third year you're bored to death. Yeah. Yep, that's actually pretty good. That's pretty accurate. That's pretty accurate for me, I think. Sean Rutledge says, could you as an opposing attorney ask for sanctions for having wasted time looking for these things? If you did, yes. Yes, you could. Let me see here. How lazy is a lawyer do you have to be to look up use AI in case law? Yes. Well, I agree. I agree. What are the oranges for? I don't know. Oh. So, talking about cutting up content, we're going to talk about David is a bit rough. Yeah, well, we'll get to all that. We'll get to all that. All right, guys. But that was kind of the interesting thing, like starting off. It's just like, where's the justice in this world? Because those guys are gonna, that's gonna be like whatever happens to them sanction wise, it's gonna be like shooting a BB gun at a tiger tank. It's gonna go bing. Whereas, like, if I do that, holy shit, I'm getting like, there's an attorney out in my neck of the woods who got caught doing that. And he's getting referred for disciplinary counsel and shit. And you're like, whoa. Like, the court nuked this guy's boots off. You're just like, damn. Damn. So, yeah. What are the odds I have some of those South African army? It's not. Okay, Edward. It's the Rhodesian army that used the short shorts, number one. And number two, no, I do not have any. Duh. So let's move on from there, chat. Let's move on from there. Speaking of Rhodesia, like our Rhodesia posters behind us. And the other one we got to put up. So. Joe Smoshos, was the lawyer near you a repeat offender for it? I don't know, because I don't know which one you're talking about. So I'm not going to discuss it further. Like I said, I don't shit in the pools I swim in. So. But let's move on, chat, to, this is actually kind of interesting. there's a lot here to it. And actually, before we get too far, I do need to address last week we talked about the National Hobby Distillers Association and their lawsuit in the Fifth Circuit getting upheld and the injunction being upheld. The attorney who litigated that stuff previously at the trial level, then at the appellate level, Devin Watkins, we had him on. He reached out to me and he said, I got some things wrong. I want to clarify those. So the injunction applies to all members of the Hobby Distillers Association, regardless of when they joined. So it's not just people prior to this, it's everybody regardless of when they joined. And it's throughout the United States, so it's nationwide. So, and what happens at that point? People who have been part of the Hobby Distillers Association, they've been requesting permits, they've been denied, and then they present evidence of being in the HDA, and they get a permit from the federal government. So there you go, chat. Like, it is a thing. I wanted to correct that. So if you want to join the Hobby Distillers Association, you can remember, you have to, not just join, you have to get a permit from the federal government. You can't just make your own whiskey on your own. You need a permit for it. So, and I get it, free men don't ask for permission, but the feds will kick down your door and kill you over this. So go join the HDA, get your permit, and go make hooch. Okay? Get your permit for it. So I just want to correct the record. I think that's important. And I want to say to Mr. Watkins, I apologize. I kind of, I got that wrong, but I wasn't sure. And I wanted to err on the side of caution. So no, free men don't get caught. Well, there's a, yeah. You can't just make your own. You can, you just need a permit. Don't just make your own without a permit. You're going to get in trouble for that. You get in trouble for that. All right. With that said, moving on to marijuana, Mary Jane, the chronic, whatever you want to call it, the dank, that Bin Laden, that AK-47, that Deep Purple, whatever you like to call it, chat. For the longest time in the United States, marijuana was labeled as a Schedule I drug. And a Schedule I drug, according to the DEA and the scheduling algorithm, it shows that these are chemicals that have no current accepted medical use and have a high potential for abuse. So you'd be like, okay, well, what could that be? Well, heroin, LSD, ecstasy, and peyote are great examples of it. Now, there's Schedule II drugs. There are quite a few of those out there. Those are a lot of the ones people abuse and people steal. Hydrocodones, also known as Vicodins, cocaine, methamphetamine. It does have some very limited uses out there, but it does work. Methadone, hydromorphone, also known as Dilaudid, Demerol, oxycodone, fentanyl, dexedrine, Adderall, and Ritalin. So yes, all those amphetamines, chat. All those amphetamines. You want to get that sideways jaw action going or grinding those teeth. You can do that. Then there's the big one we need to stop at here is Schedule III. Schedule III are drugs or substances that are defined as drugs with a moderate to low potential for physical and psychological dependence. Schedule III drugs abuse is less than 1 in 2 drugs, but more than Schedule IV. Okay, well, what are Schedule III drugs? They're products containing less than 90 milligrams of codeine per usage, so like Tylenol codeine, ketamine, anabolic steroids, and testosterone. So you can do those. But real quick, what are Schedule IVs? Things like Xanax, Darvocet, Valium, Ativan, Ambien, Tramadol. Things that you can really abuse the shit out of. But here, marijuana is right now a Schedule I. Well, there's a big change coming up in this. There's a big change coming up on this, chat. The Justice Department places the FDA-approved marijuana products and things that are subject to a qualifying state-issued license in Schedule III. So marijuana itself has not been fully decriminalized, but it's no longer Schedule I, meaning for the longest time, if you opened a medical dispensary, the banks couldn't handle your money because that's drug money. And a Schedule I drug, they can't handle it. And there were issues with that. Well, that had to get changed. That had to get messed with. You had to keep changing all these rules and all these problems. Now from here, what is going on? Well, in accordance, and this goes back to Trump signing the order in December, and we covered this when it happened. The Justice Department and the DEA announced the issuance of a immediate order placing FDA-approved products containing marijuana and marijuana products regulated by a state medical marijuana license at Schedule 3. So that means if you go to a dispensary, it's going to be Schedule 3. This is going to be interesting. They are seeking an expedited administrative hearing for scheduling of Schedule 1 to Schedule 3. The hearing is on June 29th. And it will do a timely and legal compliant way to comply with the Administrative Procedures Act and various other things there. Radcon says, does this mean the cops can't do highway robbery by narking out the weed vendors to the feds? Probably not. I mean, there's going to be, if you're just, those guys may or may not, depending on how they're licensed and regulated, maybe. It all depends. This rule is far from finalized yet. So this will be interesting. It will be interesting how this works. And it's something to keep in mind that things are making headway. Now, is this as good as making it, unscheduling marijuana? No, that has not happened yet, sadly. But it's still there. It's better than what it was, but it's not completely unscheduled. And it probably should. But once again, it's not. And remember, despite that, the government will burn your house down and shoot your dog over this still. So be careful. Be careful out there, chat. Axis, will this hearing be live? I don't know yet. I do not know. But there's some good news with that. There's some good news coming with that. And this order is going to be interesting about how this is going to work here. So with the order, though, the order is all about what they want to do. And this is, we've gone over these before when the ATS been doing like a final order in notice and rulemaking for things. This is normal for the government to do. And this format of changing things in the Federal Register. That's the CFR, guys. And this just shows you 21 CFR 1300, 1301, 1308, and 1312. And those are where you want to go if you want to look at the Code of Federal Registry to see how these things are dealt with by the federal government currently. And they'll also show the proposed changes. So the action, they want to do a final rule. They want this rule, which will be a final order. And they're going to move things into Schedule 3. That's the ultimate goal. So this will apply to marijuana as defined under the Controlled Substances Act, marijuana extracts, and Delta-9, which will be interesting the way they do this. It'll be interesting the way they do this. And other compounds derived from the marijuana plant that fall outside the definition of hemp. So there's a lot of things. It opens up a lot of things for people. And that's some good news. That's some good news here. This goes on for 30 pages, guys. We're not necessarily going to go through all of this here. But this is some good news. Now, remember, there's going to be a lot of problems. If you work for, are you going to be allowed to have marijuana in your system if you take a piss test for the DOT? No. Can your employer still drug test you and say, I don't want weed in your system? Yes. They can, just like they can say, I don't want you smoking. I don't want you drinking. They don't trust you with marijuana in your system. That is that's probably a very likely outcome. So don't think this is going to save you in that regard. If you guys were thinking that was going to happen, it's a good change. It's a good sign, but it's not where it needs to be. And honestly, if they were doing this to get votes for the midterms, this ain't going to do it. This is actually kind of a fumble in my opinion. So we'll see. We'll see, chat. We'll see. We'll see. But also, it doesn't help that Trump's also not big on like abusing drugs and all that. So, but I do think that it's very important to see what this will change. Yes, the Department of War still has, and that's the DOD for those of you out there who Didn't change the name. Yes, you guys can't and won't do weed. If you guys do weed, you're gone. That's not a surprise. Going to be a lot of places that won't allow you to use marijuana. So this is helpful for a lot of people, though, that this is getting lowered on the schedule, but not, it should be removed, but hasn't yet. So Adam saying limited autonomy equals slavery. Could this be retroactive? I don't know. I presume it won't be retroactive going forward. Gravely Dig says, what schedules alcohol? None. And regulate and tax like alcohol. Well, why should we tax alcohol? Alcohol shouldn't be taxed. The government shouldn't be taxing alcohol. The only reason why the government taxes it because everybody wants it and they can make a lot of money on it. But we shouldn't be taxing this stuff. It shouldn't be taxed. I mean, that's how I let's tax it. I'm like, how about we don't? We already have enough goddamn tax money. Okay, so Bob John says every place that's been made legal becomes worse. Yeah, well, I don't know. It's been kind of legalized, almost pretty much decriminalized here in Ohio, and Ohio's still shitty, so it didn't make it worse. I hope it will help VA guys. I wish the HEROES Act. Yeah, it could. It could. So that and that's the thing. People will still have access to things. It doesn't, it allows your doctors and other people, it allows you greater access to stuff. And Luke is saying the change won't change how you interact with it. It will change the way you can access it. It'll change how you access it. And it might make the states that it's banned in, well, it's no longer Schedule 1, so it may be eligible for now legalization. So there are possible benefits. Here. The 4473 will need to change as well. I think it will going forward because, but they're still going to say you can, if you're abusing Xanax, you can't have firearms either. So I'm not sure. I think they won't do that. But we'll see. So that is kind of it's big news, but we still have a long way to go in America. All right, guys, moving on to the saga for David, the singer. Guys, remember, he was the man accused of, they found his car, and inside the trunk of his Tesla was the body of a murder victim. And it's the murder victim he had been dating for years, since she was like 14 years old. And you're like, what? Yes. Yeah. You're like, uh-oh. The car was found last year. He was not charged. And then as of last Thursday itself, he was arrested and brought into custody on allegations he committed the murder. Yes. And you're right. I apologize. He started dating her when she was 12. Not 14, 12, which is like, I guess if you're Vito, that's right up your fucking alley, I guess. But anyways, this girl was 12, and David has been charged with a couple different counts. And in his counts here, we have a couple, these aren't everything. There's more stuff coming, chat. Don't worry. But wait, there's more. There's a lot more. And we'll get to that a lot more, because that a lot more, oh, man. Oh, that a lot more is not good. So what is it? David and people of the state of California, remember, that's how things are titled out there. And it says David Anthony Burke, also known as David. And what is it alleged here? That on or about April 23rd, remember, the car itself wasn't found until September in 2025. What does he do? Well, he's accused of unlawfully, with malice aforethought, murdering Celeste, a human being, his girlfriend, who was underage. So it's further alleged that the murder was intentional and carried out by the defendants for financial gain. It's further alleged that she was a witness to a crime and intentionally killed because of that fact. That she was a witness to the crime of him, having sexual relations with a minor. It's further alleged that he intentionally killed her by means of lying in wait. And what does that mean? Premeditation. Premeditation, guys. And why is that important to include all of this? This makes it death penalty eligible. This makes it all death penalty eligible. And California still has a death penalty. Believe it or not. It technically still has it. They don't use it, and they commute everybody's sentences, but they still have it. They say it's further alleged that in the commission of this, he personally used a dangerous and deadly weapon, a sharp instrument. And, those are talking about that. Count 2. He did unlawfully engage in 3 more acts of substantial sexual conduct and 3 or more lewd and lascivious acts with Celeste, a child under the age of 14 years old, while the defendant resided with and had reoccurring access to the child. No. Yeah. Yeah. Yeah, she was found after her 15th birthday, but she was dead for a while, so she was killed at 14. Yes. Remember, guys, they alleged she was killed in April. The body wasn't found until September. That body sat in the trunk all summer long, decomposing. So then count 3. He's also charged the unlawful mutilation of human remains. He did willfully and unlawfully mutilate the remains of somebody known as Celeste R. And yeah, those are the complaint. That's the felony complaint, chat. Not an indictment, but a felony complaint. Now, there was an entire press conference that's about 20 minutes long. But during the press conference, the prosecutor's office indicated they searched his phone and his iCloud, and they found cheese pizza on it. Ooh, they found some cheese pizza on there. Now, other things have been released. This is for the medical examiner's office. This is Celeste Rivas. This is her coroner's report that's there. There are a bunch of markings and a bunch of defects which indicate that she was stabbed multiple times. There were different stab wounds. There were different, when you see these defects. There's a lot of issues with how what happened. She got stabbed to death. And here's some of the major stab wounds you can see on the body. Right here and right here. And you hear, it's a 3/4 inch defect, 3 to 9 o'clock, and they talk about how she got stabbed to death. And that's really looks like there. That's what it really looks like there. The other thing here is, yes, and you're right, Kay, I forgot to mention this, I saw it earlier. Absent. What's absent? 2 of her fingers are missing. 2 of her fingers are missing. Was that pre-mortem or post-mortem? We don't know. We don't know when that happened, but he chopped some fingers off. Like Soprano style. So, yeah. So, with all that being said, he did have his arraignment a couple days ago. And that is something we can watch real quick because it will see you and you can see what happened there. And we'll get right into this here, you guys.
My team will come around to you and we will have something.
Josh, you said
Calling People versus David Anthony Burke. That's case number 26 CJC F02399.
Good morning or good afternoon, Your Honor. Blair Burke, Marilyn Badnarski, and Regina Peter on behalf of our client, David Burke, who's in custody.
Thank you. Good afternoon, Mr. Burke.
Deputy District Attorney Beth Sullivan with the people, Your Honor.
Thank you. And counsel, on behalf of your client, do you waive formal reading of the complaint, advisement of rights, including armed forces and veterans' rights, enter a plea of not guilty, denying any and all special allegations, enhancements, and priors?
Yes, Your Honor.
And requesting a preliminary hearing within the period?
Yes, Your Honor. From the media reports, apparently there have been 4 months of secret grand jury proceedings. We believe that Mr. Burke is entitled at the earliest opportunity to an open preliminary hearing and the proceedings not be done in secret. So we are asking for a preliminary hearing to be set at the earliest possible date on the 10th day. Your Honor, we believe the actual evidence will show David Burke did not murder Celeste Rivas Hernandez, nor was he the cause of her death. And we would like to be able to have the evidence come into the light of day at the earliest opportunity in order to establish that. We're asking for April 23rd as a 3 of 10, Your Honor.
Anything from the people?
We'll be very happy to put on the evidence that we've collected in this case over the last several months.
Thank you. So the matter will be set, plea of not guilty has been entered on behalf of Mr. Burke. The matter will be set in Department 105. The matter is ordered assigned to Judge Charlene Almeida in Department 105 for all purposes by the judge of the supervising judge of criminal.
Yes, Your Honor. If I may just put on the record, we have, as soon as the people arrive, delivered a informal discovery request consistent with Penal Code Section 1054. We have been given almost no discovery thus far. We've received a 3-page follow-up report, no autopsy report, and a copy of the complaint. And we would ask the people respectfully to produce discovery at the earliest opportunity.
Your Honor, as I've indicated to counsel, there's approximately 40 terabytes of discovery in this case. Moreover, in order to obtain the transcripts from a grand jury investigation, counsel has to file a motion. She knows the way the system works. I'm not able to gather those. They have to be provided after the court orders them released because it was an investigation. Second of all, if counsel plans on going to a preliminary hearing within the 10 days, it is unlikely that there will be very much discovery provided within that period, given the voluminous nature and how long it's going to take to copy onto drives. In addition to that, the coroner's report was sealed in this case in order to prevent it from hampering truthful testimony from witnesses that testified at the grand jury. So an order will also have to be obtained in order to get the coroner's department, which is now the medical examiner's department, to release those materials.
Your Honor, it's surprising news given the District Attorney's Office held a press conference this morning where they discussed the cause of death apparently under seizure.
And this is the funny part. This is where, you know, the prosecutor want to go and wave the flag and, oh, we're going to dab on, oh, dab, we got him. Well, now the defense can say, well, you guys are just talking about it like a bunch of chatty Cathys.
And not released by the coroner's office, as did the robbery homicide unit to the press. So we would again reiterate, we believe that Mr. Burke is entitled to discovery. We have served the people with notice. They have 15 days to produce discovery in this case. We would ask that they do that in conscientious earnestness and as quickly as possible.
I'd ask the court to make an order today. We'll take a copy of the minute order, ordering the Department of Medical Examiner to release their coroner's report in this case.
Thank you, Your Honor.
The court will order that the medical examiner release the report in this case forthwith.
Thank you.
The matter is set in department 105, as the court indicated, April 23rd, 2026, as a 3 of 10 agreement. Anything further?
No, not at this time.
Bail to stand at no bail. Thank you.
Thank you, Your Honor.
Well, there you go, guys. That happened today. There wasn't much of an update on that because prosecutors disclosed, there's a ton of cheese pizza that we need to go through. And some of you guys are saying 40 terabytes, that's a lot. I mean, not if you have a phone and you're using your phone all the time. I mean, doesn't take that much data if you're using it all the time. And somebody like David is probably using it all the time. And it doesn't help that his girlfriend, this 14-year-old he's been seeing, everything with her is going to be sexually related. So it's going to be all child sex abuse material. So that is the problem here. Being held on no bail, he's still being held on no bail. As is, very typical when you're charged with a murder like this. No bail, and you're, international ties, you've been all over the world. Yeah, you're going to get no bail. But even if not, for us, it's going to be all no bail, too. And ultimately, there hasn't been a new date yet, but this is just going to go on and on and on. And I mean, it's too early yet to say, chap, this doesn't look good. This does not look good for David. Does not look good. I mean, just dating the 14-year-old already looks bad, but yeah. So keep that in mind. We'll see where this case goes, but I don't have a lot of, I don't think it's going to turn out well. V2 me loses for $10 says, I hate seeing this happen. And from such a great musician. The lyrics, up the floor, did a pomo gub, better be that Tom, a fucking big snood, cough bin dub, homofucker in his song, my dick, really spoke to me. I know, it's just, he is the warrior poet of our generation, a true bard. So, how are we going to cure cancer now? I don't know. Is there a reason why it took so long to charge him? I think they were just taking their time, Phil, from what I could tell. This was a very deliberate investigation. Also, they waited until he got back, because otherwise, like him, he could leave at a moment's notice. So there were a lot of concerns about him running. But I think they really wanted to make sure they, dotted their I's and crossed their T's, because if they didn't, it's going to be a disaster for him. Joe Schmo says, see, nothing good comes from TikTok. Very true. Very true, chat. Very true. Is he related to Eric Swalwell? No. But that's a very interesting one. I listened to the press conference earlier today while I was driving around, and it's like, this guy sounds like a top tier, he could have run Hackamania. Let me just say it like that. Chat. Okay. Hold on here. Where are we at? Okay. This one here, it's this is a bit of an Ohio story. And it might not seem important, but I do think it matters. I still live in Ohio. I won't be here for the elections in November. I'll be a Florida man by that point. But this is kind of interesting what the Supreme Court of Ohio did. And I wasn't aware of this, but they did this. The Supreme Court has removed their ban on judges endorsing political candidates. Huh. Now, that's what it says, and that's true. But it's interesting what this case comes from. So the Supreme Court on a 5-1 ruling. Ohio has 7 justices. I'm not sure why they were involved. But they said that you can make political endorsements because it's a violation of the First Amendment. Now, Ohio is now the only state to explicitly allow judges to make partisan endorsements, which is insane. We're the only state, but I guess it's based in one way. Now, how did this work here? Well, we're just going to go through this. It's interesting how this case came about. Because when you read it, you're like, okay, well, how does this come from there? And it comes from a disciplinary case. And it comes from this case here. And when you ever, in Ohio, if you ever see this disciplinary counsel versus so-and-so, that so-and-so is generally having a very bad day. The disciplinary counsel is the Office of Disciplinary Counsel for the Supreme Court of Ohio. So if you ever get a letter, I've more than once about crap my pants, opening up the mail and you're flipping through your letters and you see, bam, Office of Disciplinary Counsel. You're like, ah! And you open it up and they're like, do you have information about this? And you're like, okay. Oof. But it'll make your blood run cold. Let me tell you what, chat. It'll make your blood run cold. But this is about a judge. And remember, guys, it was 5-1. We have 7 justices. One of them did not participate, and I'm not sure. She must have had some sort of conflict. But here's where it starts. John Ruddock has been an attorney since 1976. Okay. So what happened? Well, there was a complaint. And what was it? Well, at the time, he was a common pleas court judge. And a common pleas court judge, Chad, is a judge who handles all the matters in a court of common pleas. So, and in Ohio, common pleas are the typical things that would be done there. Felony cases, civil cases over a certain amount. But as part of a court of common pleas, that includes domestic relations, so divorces. That also includes technically the juvenile court. Is technically you are running for the court of common pleas as a juvenile court judge. There's also probate court as well as technically part of that. So it's the courts of common pleas. And what did he do? Well, he was endorsing his son on Facebook, on his personal Facebook page, for a seat on the Clinton County Municipal Court. Clinton County, guys, is in Southwest Ohio. If you guys know where Wilmington, Ohio is, that's down that way. It's a nice place. He was tagged in posts endorsing his son, shared many of those posts, and one time posted a lengthy essay defending himself and his family on his Facebook page. So ultimately, he got charged with misconduct, and the Board of Professional Conduct recommended the court publicly reprimand him in order to remove all the posts. The boards adopted the panel's findings and conclusions of law, but they point out that ultimately we are the ultimate arbiter of misconduct and sanctions in disciplinary cases, meaning Supreme Court. We are not bound by factual and legal conclusions, either by the panel or the board. And that is true. And I think in most states that's the case as well. Your Supreme Court is the one in charge of enforcing things. So there are times where I've seen attorneys. There's cases where the attorney and disciplinary counsel or whatever local bar association handles a situation, they negotiate something out where it's like 6 months suspension of your license, 6 months a stay of that suspension, meaning basically you're put on probation. Or you get a reprimand or just an admonishment. Okay. And then the Supreme Court of Ohio comes in and goes, no. And they go like, skaboosh! And they just nuke the guy. And they nuke him, they smack him pretty hard. They yank his ticket for like 6 months or a year. There are also times where the disciplinary board and the judicial conduct board nuke a guy, and they want this guy to make his suffering legendary in hell. And the Supreme Court steps in and goes, we're not going to do that today. We're going to give this guy, we're going to take a break on him. So that can happen. I take a good, is this in Lickum-Low-Lisa County? No. That's actually further south on the Ohio River. That's in Adams County, Ohio. But it's down that way. Kind of. So ultimately, the Supreme Court had to determine, did the Facebook activity while serving as a judge violate judicial conduct rules? Ones that require you to promote independence, integrity, and impartiality. Are you prohibited from abusing the prestige of your office to advance personal or economic interest? Prohibiting a judge from publicly endorsing or opposing a candidate for another office. Like, there's a specific rule. Okay, so they go through all of this. And they conclude that the rule prohibits speech that's at the core of First Amendment freedoms. Speech about the qualifications of candidates for office. And they say, and that's a First Amendment issue, as a content-based restriction, the bar against judges endorsing candidates does not withstand strict scrutiny, as is not narrowly tailored, and this is the test for strict scrutiny, narrowly tailored to serve a compelling state interest. So they're already within five paragraphs of their opinion, they're already saying, nope, one of these is not valid anymore. Citing disciplinary accounts versus Grindel. Guys, a bunch of you have sent me, will you take a look at this case? I am not going to. I will not. Even if I move to Florida, I am not talking about that case. I will not touch it with a 10-foot pole. That one's not a good one. I am not touching it. If you want to send that to Kurt or Uncle or whoever you want, go ahead. And I've told you that in your emails. I will not talk about it. They'd say they therefore hold that one of the rules of judicial conduct violates the First Amendment, and therefore a violation of the rule cannot serve as a basis for discipline. And because the violation of Judicial Rule 1.2 was premised on the finding of violation of 4.1, the Rule 1.2 violation can also not serve. And upon a review of the facts, we conclude that the Facebook activity did not violate Rule 1.3. So this judge, suffer justice. No, this judge just won. For these reasons, we dismiss the complaint. Boom. Boom, boom, boom. So this guy had a personal Facebook account, and he was identified as a judge on it. It was a public profile. And, he put in their stuff, all their thing there. He shared posts of his son. And, in 2023, his son decided to run for a seat on the municipal court, which is below him. And he, his son wrote several posts and tagged his dad, which, good job, son, getting your dad dragged in it. But he did. So they go through all of this, and the court just goes on and on and on and addresses this. And it's, we don't really need the facts here, but they point out, you can't do this. You're not, you can't restrict the judge's speech. So therefore, this judge did nothing wrong. It's very interesting. So judges can now do it. And they say, judges do not give up their First Amendment right to engage in political speech simply by assuming office. Also, it was really interesting when I read this case earlier. There's an entire, I didn't know what a judge I was very close to got in a little trouble back in 2020, and I didn't know about it because I had left town already. So it's kind of interesting. He's still a good judge, though. I still respect him. They said, well, we acknowledge the state has a compelling interest in maintaining independence, integrity, and impartiality. The rule sweeps too broadly and restricts political speech beyond what's necessary to uphold those state interests. We therefore conclude that applying the rule against the judge would unconstitutionally infringe on his First Amendment rights. And they also say that the Facebook activity does not violate Rules 1.2 or 1.3. So in this situation here, judges can endorse political candidates. It's very interesting. It's very interesting here how this works. It's just when you think about this, you're like, oh, well, this makes sense. But no, it was a whole disciplinary case. It wasn't somebody suing for a right. It was a judge, that was facing bar discipline. And he won. He goose-egged the disciplinary council, which is really impressive. That rarely ever happens. But yes, this, homie, and that's another thing too. When we read these bar complaints, usually someone's just getting killed. No, this one, fucking rack it up. Fucking dub for the judge, man. Dub for the judge. Yeah. I take it good, says the judge nepoing his son on a bench should have been the focus. I mean, it's Clinton County, Ohio, dude. Like, there's a Republican primary. I mean, like, you know, it's not like the Democrats were going to win that. And let me see here. Who's actually the judge right now? Well, it didn't matter anyway, because going to the website, chat, his son did not win. His son did not win, so it didn't matter. What is the case? Everybody's emailing me. Discipline. I guess I'll scroll back up to it. Where is it? Bunch of people have sent this one to me because it's literally in my neck of the woods. But I'm not doing it. Where is it? Here. People want me to do this case right here. Disciplinary counsel versus Grendel. This one is it's where I practice. So I'm not touching it. I'm not touching it. Nope. Call me a pussy all you want. I am not touching it. Call me a... It's like Chris Rock said, you call me a faggot all day long, but I'll be like, he's like, I ain't fighting the Russians. You call me a faggot all day, but I'll have both my legs saying, hey, what's up? It's like, I am not getting involved in that. I am not getting involved in that. You can call me a pussy. That's fine. VTubing enthusiast says, back in 2010, Antonin Scalia gave speeches at Tea Party groups. Judges are allowed to engage in politics in the U.S., like it or not. And that's fine. That's fine. Because you know what? Nobody can discipline Antonin Scalia. There is no, other than impeachment, there's no way to discipline him. There's nobody that oversees him. He is a judge without any oversight, really, from disciplinary terms. It's very different for him. Very different for him. Pussy. Yeah, well. Yeah, whatever. Whatever you want to say. Whatever you want to say. Yes, in a non-official capacity, he could say whatever he wants. In an official capacity, I think not. Yeah, well, that's the issue. It's not as though he's sitting on the bench. Like, we talked about that with some of these other judges where they say, like, you know, vote for myself or vote for whoever. No, this judge was on his own time out being a boomer on Facebook. And they were like, you can't do that. It's like, but why? Why can't you? No, it's interesting. It was interesting, though, because Ohio was pretty tough on judges for this stuff before. And I've seen cases where judges got smoked by that. Radcon says, how much tea are you going to spill once you move? None, because because God knows I might have to come back. We might move back at some point. I don't know. Number one. Number two, I won't do that just because it's just not prudent. It's not prudent. So that's the thing there. All right, let me see here. Did I miss anything? No, I think we got that. Oh, Everett Scott says with the David thing, hey, we went full Russian with the court out there. That's still set up from COVID, man. That's a COVID setup. If you notice, they had like that hockey glass sitting in front of the prosecutor. That's all COVID stuff. And some places that never went away. There's a court that I've been to. I was there this week as a Monday. There was still some COVID protections up. There's some crazy. COVID's made people crazy, man. COVID's made people crazy. So, but moving on from there, chat. This is, speaking of the Supreme Courts, we kind of touched on that. The shadow docket. This is something where the Supreme Court makes those rulings and they show up in the orders that get presented. And it started really back in 2016 as kind of the official time for it. And most of the things the Supreme Court does, it's shrouded in secrecy. We know what they do and we know how they do it, but we never get to learn about what happens. We know how a scheduling conference is, where they put down what cases they're going to consider. And we know it requires 4 votes to get certiorari. And we know what date they're doing it. We understand that the newest justice has to take notes. We understand the newest justice is responsible for refreshments and stuff. But we know a bunch of these things that exist. And we understand how it happens. But we never get to know what exactly happens and who says what. With all of this, though, that changed. Remember, with the Dobbs decision, that got leaked. And there have been leaks about other things. And apparently Alito is not retiring this year. Neither is Clarence Thomas, which is kind of a big deal. Because people thought Alito was going to retire because of his book. Also, he's getting old. Clarence Thomas is repeatedly, he doesn't want to die on the bench. But he's not quitting anytime soon, it looks like. But these things are leaking out. These things are leaking out. And this bomb dropped at the end of the week, last week. Supreme Court correspondence got leaked. And this is going to be very hyper technical if you guys were not going to, don't worry about reading it. Just acknowledge what this stuff is, because it's something you've never seen before. You have never seen it unless you clerk for the Supreme Court or work there. But they talk about in 2016, the Supreme Court halted an ambitious climate change initiative on a 5-4 vote. The order was 1 paragraph long. And this became the birth of the modern shadow docket, as things are known. This is a very common thing, okay? So this goes back to 2016. And this talks about a 1-paragraph ruling that came out, chat. A 1-paragraph ruling. And it was very simple. It was very simple. But from here, we've now we're seeing the thing happen in real time. So here it is. This is something we should never have seen. No, Mayo says, I saw this on NPR like 9 years ago. Well, the New York Times broke it as though it's brand new, and I never saw it on NPR, so thank you, No Mayo. Memorandum to the conference, and this is the West Virginia versus EPA case, a bunch of cases versus the EPA from the chambers of the Chief Justice. And this is from down here at the bottom, guys. When you see, sincerely, John G. Roberts. This is really him. This is from him to the other justices. And he's talking about emergency and guys, this is that shadow docket stuff here. They talk about emergency applications for stay. And we've seen this in other stuff that's gone on in the past year. And there's the shadow war basically with the shadow dockets, and it's about the clean power plans, which by 2030 will rule to achieve CO2 emission reductions from the utility power corridor of 32%. And he says within weeks of the rules publication, 27 states and several labor unions filed petitions for review and applications for an immediate stay. And he says, I requested a response on a bunch of these things. And he says, absent a stay, the Clean Power Plan will cause and is causing irreversible reordering of the domestic power sector before this court can have review its legality. So he's saying we might need to do it. And he's saying a stay is appropriate if a bunch of things happen here. And in a closed case, it may be appropriate to balance the inquiries. And notice, this says Conkright versus Frommert, right? It says Ginsburg J in Chambers. They're citing their own stuff here. They're referring to their own documents in Chambers, chat. Because this is in Chambers, meaning not in the public. You know, there's all kinds of things here. And he says, I have little doubt there will be a petition for cert, regardless of what happens in the D.C. circuit. And he says, I find it very likely that 4 members of the court will vote to grant the petition, again, regardless of the outcome below. He says, I also believe there's a fair prospect of reversal. And he goes on for this. He lists a lot of things here, you know, that the criterion for the third stay, irreparable harm, has been met. And he goes through and he lists all this stuff out. Notice, this is all the stuff they do while they're arguing with each other, chat. Think about this. This isn't just a, hey, Bob, I think this is bullshit. No. Like, look at how in-depth this is. You know, a quarter of a page footnote. And all the things that are cited here. This is not just any joke. This is a lot of stuff here. He says, I recommend granting the stay. Okay. From Justice Stephen Breyer, guys. And you guys remember Stephen Breyer? Well, he was a long time ago, many moons ago now. And he says, I would issue an order in these applications along the following lines. And this is where he's saying, what he wants done. And he says, I prefer temporizing the order of a grant of these stays for several reasons. He says, first, it's unusual to issue a stay of an agency's order during the time the Court of Appeal is considering the lawfulness. He says, it may prematurely suggest a view on the merits of the question that now seem difficult. And he goes on to say, I don't see how a few extra months will make a significant difference. Well, that's because you're a commie. And he goes on to say, sincerely, Stephen G. Breyer. And that's his response. Well, what do we get again from the Chief Justice writing back? And he says, I believe that an immediate stay remains the appropriate action. He says, there are no aspects of this rule that are not challenged here. And he goes through and he says that, the cost of this had been estimated to run as high as $480 billion from 2017 to 2031. And he says that, the EPA could overreach in the absence of a stay in unusual circumstances, effectively evades judicial review. And he's talking about, they had another case already with the mercury air toxic standards reviews. And once again, he cites this case that Ginsburg did while they were in chambers. And he goes on, he says, there's nothing unique about this. And it is interesting how they phrase all of this, chat. Once again, signed by John Roberts. And then Elena Kagan, Justice Kagan jumps into the mix. And notice how this is worded. I agree with Steve, meaning Justice Breyer. We should direct the state to seek an extension. It's just interesting. She calls him Steve. Also, hi, Maddie. Hope you're doing well, man. And it's just, hey, Steve. Oh, hi, Mark. And she goes through and she's throwing things in here. Further, I agree with Steve. The applicants have failed to demonstrate likely harm. And she goes on to address this sincerely, Elena Kagan. And then she goes on further to say, I agree with Steve's proposal and Elena's supplement to that proposal. This one's cut off, so who wrote this one? So notice, now we have Steve and Elena. Well, who wrote this? And that wasn't listed, but I believe that was Sotomayor. Then notice, from the chambers of Samuel Alito. And he says, I agree with the Chief Justice's most recent memorandum. And he goes on to say that there is irreparable harm here. It's just interesting to see how these guys are going back and forth. And notice, though, Sonia and the SG, meaning the Solicitor General, notice how they address each other. It's different than they would out on the floor of the Supreme Court. We've never seen this before. But yeah, sincerely, Samuel A. Alito. And then Anthony Kennedy. These people. And he says, the memoranda from the conference have been very helpful. In my view, a stay would be granted in 4 to 6 months in any event. In fairness to the parties and councils, that we should grant it now. He says, therefore, I agree with the recommendations. Signed, Anthony Kennedy. Isn't that kind of cool, chat? That's pretty cool. I mean, I'm not thrilled that they did this. But somebody leaked it all. Somebody leaked it all. And should they have leaked it all? No. But someone did. And, we're going to make the most of it. We're going to make the most of reading what we have here. I think this is while it's neat, this also signifies a degradation of the Supreme Court as an institution with more and more and more and more leaks, which undermines its legitimacy and allows it to be manipulated. And the previous leaks, we never found them. 100 people were investigated and nobody could pinpoint it. Although, yes, as I agree, very likely came from Sonia Sotomayor's office. If not, probably from one of the justice herself. So. It does. I thought it was really cool from that aspect. It's, just something to think about, something that's going on in your world. You guys need to know, learn about it. Helps you just prepare and address what's going on for yourselves out in that world. I think it does very, very well. Now, moving on to some other stuff here. Chat. Laura Loomer. Guys, remember Laura Loomer sued Bill Maher for allegations that she was having sex with Donald Trump and that Donald Trump had got her pregnant and that she was doing all kinds of things for him. Well, Laura Loomer sued Bill Maher and HBO in what I thought was truly a lawsuit and was very ridiculous. Well, as of yesterday, there was a ruling on that in the Middle District of Florida. And ultimately, the plaintiff does not establish the elements of a false statement, malice, or damages. As a matter of law, accordingly, final judgment will be entered in Bill Maher's favor, which is fair. Laura Loomer's, there is not an Israeli move she doesn't like, and she sued Bill Maher for this, and yeah. That is really kind of it for Laura Loomer, really. But I thought it was really important. I thought it was wrong for her to go after that. Meme Copian said, "How's the weekend looking?" Shot. I don't know. How was your weekend? How was your weekend, Meme? Remember, chat. Also, once again, I need to address this. Chat, speaking of that, with Meme Copium here, go to the dragonstreasure.com. Use the promo code JUBEL for 15% off. 15% off. Or if you want to give the team man a little more of your hard-earned money, which there's nothing wrong with doing that. I totally understand it. You can use the promo code CRIMINAL and save 10% off. Because really, guys, who wants to cope? Why would you proudly type in, "I'm coping"? No, you wouldn't do that. Have some respect for yourself. Promo code CRIMINAL, 10% off. Or promo code JUBEL, JEWBULL. Get you 15% off store-wide on, coffee made by the T-Man. And not coffee brand coffee or Cucky brand coffee, but T-Man brand coffee. Do it, chat. Do it! You'll feel better for yourself. No more streams this week. He's got somewhere to be. He's tapping out, chat. He's tapping out. Jeremy scared him. Jeremy came up to him and Meme's like, "All right, I'll tap. Tap, help." No, Meme did a good job this week. Really banger shows. 1,000 plus, multiple days in a row. I need to consult with Meme on how to get my numbers up. I know there's a couple of us out there in the LawTube sphere who could use some benefit for talking to Meme Copium and get our rookie numbers up. So that's something we could do, and that's something I need to do here. So hello, Meme. Yes, Meme has a real job. He is a practicing tourism professional. Yes, Meme said, "I tried doing food reviews." Well, you mean like cooking reviews? I need to find videos of people doing cooking. Maybe that'll help me. Or a cooking show, yes. Dino streams may help as well. Mystery Sniper, yes. Yes! Hitting all the emojis. All right. Meme doesn't work. The SPLC was paying him. Oh, that would be funny. All right, guys. So, yeah, Laura Loomer took a big old L here. And, couldn't happen to a nicer person. Couldn't happen to a nicer person. All right. This next thing. I thought this was a joke when I saw it. But apparently, a member of the U.S. military, in particular a soldier based out of Fort Bragg, and may or may not have been involved in SOCOM, made a bunch of bets on Polymarket like the day before the raid to go capture Maduro. Yeah. This is not a joke, chat. This is not a joke. This really happened. This really happened. So, yeah, let's start here. Let's start with this. So the Southern District of New York, chat, remember, they're the court that believes they have jurisdiction over everyone. And for a financial crime, I guess they feel like they do. Okay, so who is this? Gannon Ken Van Dyke. So what do you do? The unlawful use of confidential government information for personal gain. So what did he do? Well, he used a misappropriated classified non-public governmental information about a U.S. military operation. Okay, well, which operation? Well, it was the operation to capture Nicolas Maduro. So the op into Venezuela called Absolute Resolve. That's where we went in the middle of the night and just snatched him out. He made more than $400,000 in illegal profits. At that time, he was an active duty member of the U.S. Army and had access to classified material. Van Dyke decided to use that material to place trades on a prediction market for his personal profit. He subsequently tried to conceal his unlawful use by obscuring the source of unlawful proceeds and disguise his connection to accounts linked to the trades. Okay, so here we go. Since in or about 2008, Gannon, the defendant, has been an active duty soldier in the U.S. Army. Since around 2023, he has been a master sergeant with the United States Army Special Forces. Now, this is where I don't think this guy's on an ODA, like an operational detachment. He's not like an 18 series, I don't think, because 15 years, I don't think he would be eligible for SFAS, Special Forces Accession and Selection. But I do think he was probably attached to a Special Forces group or to some SOCOM entity, as it were. But I do not believe that he was in charge or, was a, snake eater himself in this situation. So, but, the 1st Special Forces Command, that's where out of Fort Bragg. 3rd group is also out of Fort Bragg. That's the group there. And, they have, like I said, they are there, but I think, I forget how all of it's all structured out, but, they are to deal with like sub-Saharan Africa, I think, and like Eastern. They're mainly Africa based. Because there's a couple of different commands. There's like the Special Forces Group, which does all the stuff in the Middle East. They were heavily used during the GWAT. There's like the 7th group that does like Latin America and Southern America. We have like the 10th Special Forces Group, which does like Europe. And then you have like the 2 National Guard type Special Forces units, the 19th and 20th group. And yes, we do have National Guard Special Forces teams. It is a real thing. It is a real thing. So, but yeah, he could have been a lot of different MOSs. The guy's not like, this guy wasn't like a Green Beret. He probably was attached to the unit. But anyways, at all relevant times, he was stationed at Fort Bragg, and Fort Bragg houses the 82nd Airborne, the Airborne Corps, the Army Special Operations Command, and JSOC, which is the Joint Special Operations Command. It's also home Delta Force and other really high-speed Black Ops entities and like Tier 1 units. And so anyways, what did he do? So in 2018, well, he signed his Sensitive Compartmentalized Information NDA, meaning he knew that he couldn't divulge anything marked SCI or knows to be SCI to anyone who doesn't have a clearance and has no need to know. So he knows that he can't do this. On December 8th, 2025, he signed an NDA agreement regarding the Western Hemisphere operations. Pursuant to the agreement, due to his association with SOCOM, he may be granted access to information and plans concerning the security of the United States. So he knew the date and time of the raid. Eric says, Nat Guard is 20 group. Yes, but it's also the 19th group. There are 2 National Guard groups. And then from December 8th through at least January 5th, he was involved in planning the execution of Absolute Resolve. Now, who knows what he actually was involved in, but he would know the date and time it's going down, how it would go down, probably a lot of information. He was aware that he had access to classified government intel. He uploaded to his Google account a screenshot displaying the results of a Google AI query. And the results stated that the U.S. military special operations have numerous classified file records and operation details that are not available to the public, even when it's released, and goes through all of that. So he already knew, like, for some reason, he screenshotted him asking AI about classified information, which I don't know why you did this. But anyways, he uses Polymarket. Okay, so Polymarket was the prediction place, and they offer hundreds of bets and markets where you can wager on the outcomes of everything from sports and politics and pop culture. So markets basically are, will X happen, yes or no? At resolution, the share on the correct side pays $1. If you're wrong, you get 0. If you grant yes and there's 75, the market receives a 75% probability. The yes share will trade at 75% or 75 cents. So you can get Polymarket anywhere. Polymarket's stable to USDC, the Tether, which is pegged 1-to-1 with the US dollar. If you guys have ever dealt with it before, that's the stabilizing currency in the crypto market. So what did he do here? So during the fall and winter of 2025, Polymarket began offering contracts and bets on Venezuela and Nicolas Maduro. On September 6th, Polymarket posted a market offering of the likelihood of U.S. forces in Venezuela by certain dates. On November 3rd, Polymarket hosted an arguing of Maduro being out or removed from power by certain dates. On December 17th, there was another one regarding the future likelihood of U.S. invading Venezuela on or before January 31st. On December 18th, Polymarket posted one about the likelihood of Trump invoking the war powers against Venezuela. So on December 26th, he used a VPN connected to Polymarket, which geolocated a foreign country, which you're like, oh, wait, he used a VPN. How'd that work? VPNs save all your data. It's all a scam. They're selling you something that really doesn't help you. Unless you're using a VPN to watch Netflix from another country. VPNs don't do dick, chat. They're selling you snake oil because they have to document you coming in. And now they have your information. No bueno. No bueno. So on December 27th and on or about January 26th, he purchased $33,934 worth of yes on Venezuela and Maduro related bets. Oh, I mean, yes, you should use a proxy, but most people aren't smart for that. Most people aren't smart. They're just thinking, oh, I use a VPN, I'm safe. No, you need layers. Even then, this is going to get him in trouble. This is the problem that we talked about this, though. This is a problem when you're doing these bets. How do these guys get caught in the sports gambling stuff? They bet like $100,000 on something that makes no sense, and then they win. Remember, guys, pigs get fat, hogs get slaughtered. Dropping 30 G's on something is insane. Absolutely insane. So on or about December 27th, he approximately got 634 shares of U.S. forces in Venezuela by January 31st, at the average price of 15 cents a share, for a total purchase price of about $96. On December 30th, he got 13,000 more Yes shares at an average price of 9 cents a share for a total purchase price of $1,200 in U.S. digital coin. Also on December 30th, he bought 850 shares of Maduro out by January 31st at 10 cents a share. On January 1st, he purchased 17,858 shares of the U.S. will invade Venezuela by January 31st for $1,700. He also bought 1,700 shares of Trump using the War Powers Act. 73,000 shares of Maduro out by January 31st at like 6 and 7 cents respectively for a total price of $6,100. On or about the morning of January 2nd, he purchased another 3,000 shares. And then he bought another 90,000 shares. This guy's insane. You can't do this. You can't do this, guys. Come on. That evening, he also got another 82,000 shares. He also transferred additional funds into his Polymarket account, which I'm betting was linked to his bank account, which even if you're using proxies and VPNs, when it shows your Polymarket account is tied to a bank account owned by Sean Patrick Martin, who lives in Lake County, Ohio, I'm sure they can figure out who the fuck you are. Whoa. Oh, no. You could have 100 proxies at that point. He kept on buying these. He bought 87,000 shares of Yes. I mean, this guy bought so much. Yeah, the transaction of money can never be anonymous. You know, he bought 7,000 more shares. 45 minutes later, he bought another 88,000 shares. I mean, he was involved in the planning and execution of Absolute Resolve. He possessed non-public information about it. And he received this related to this, that he was under a duty of trust and confidence to maintain confidentiality. By misappropriating the information to execute trades, he breached his duty of trust. Yes. The United States announces Maduro's capture and he cashes out. Remember, chat, we were live for this when it happened. Long King says, we get kicked out of the military for this? He's going to Fort Leavenworth, man. Yes, but he will get kicked out of the military. On January 3rd, United States Special Forces operators, and from what we understand, it was one of the Sabre squadrons of Delta Force, along with a couple of FBI HRT operators, because those guys are technically law enforcement officers. They're federal agents. They were the ones who actually arrested Maduro. So Delta Force went in and schwacked all the Colombian mercenaries. We bombed Hugo Chavez's mausoleum. We took all those Chinese surface-to-air missile sites and we broke all their shit and flew home. No casualties. There was the one helicopter pilot who got shot in the legs and he flew it home. And at the State of the Union was announced that he was getting the Medal of Honor. So there was some real cool shit on that raid. So anyway, January 3rd at 5:45 a.m., just hours after the military apprehended him, a photograph of Gannon Ken Van Dyke, the defendant, was taken and uploaded to his Google account. That photograph appears to be him on the deck of a ship at sea, wearing fatigues and carrying a rifle, standing alongside other individuals wearing military fatigues. Huh. Following the announcement, Polymarket resolved several Maduro-related contracts to yes at $1 a share, including all of the ones out by January 31st and U.S. forces in Venezuela by January 31st. As a result, he won his wagers on those contracts. On January 3rd, he sold his positions for a profit. And what did he do? He avoided losses by selling his positions before some of these resolved. So as the raid's going, he's making trades. This guy's literally like on a black operation, and he's sitting there making trades. Insider trading in a military operation. Like on some black ops shit, and he's out there making trades. I love him. America is the best country in the world. I love this place. I love this country. I love this country so fucking much. Ultimately, he profited $409,881. Woo! Wow. That's better than E7 or, well, Master Sergeant's E8, right? Oh, it's E8. That's better than an E8 pay grade. Following successful trading, he transferred and disguised the proceeds from his scheme. He withdrew the funds, including the majority of it, and sent approximately $437,000 to a foreign crypto vault, which advertises it generates interest by lending crypto and other tangible assets. He transferred approximately a couple days later. He transferred $444,000 of USDC, which is basically $444,000, from the crypto vault to his crypto exchange account. From there, he withdrew $44,000 and deposited into a newly created brokerage account. You can't move money like that. You can't just move money like that. You're some schlubby E8, and all of a sudden you got 400 G's in your pocket. You can't do that. You can't do that. Yeah, this is not enough to risk going to prison for. Yeah, and crypto is public. It's meant to be traceable. The brokerage account contains a balance of $415,000. Shortly after the announcement of the capture, reports of unusual trading on Polymarket appeared in the press and social media. He then took steps to conceal his identity. On January 6th, he asked Polymarket to delete his account, falsely claiming he had lost access to the email address. That same day, he changed the email to his crypto exchange to an email that was not described to in his name. So what did he do ultimately? Well, he committed some crimes here. He used non-public material and government information to personal gain. That's a big problem. Can't do that. You can't do that, chat. Count 2, theft of non-public governmental information. What he did was theft of governmental information. Count 3, commodities fraud. Guys, remember, it's trading and speculating. So, it's a commodity in interstate commerce and for future delivery. It's subject to rules of a registered entity. Yeah, so now you're in securities fraud territory. Not good. Not good. Count 4, wire fraud. He used the means of wire, radio, and television communication, interstate and foreign commerce to defraud. Count 5, engaging in a monetary transaction in property derived from unlawful activity. That's also a crime, if you didn't know. Everything's a crime with the feds. And they're looking to seize all the stuff that he's out there, $50,000 in currency at his USAA bank account. They're looking to get everything they can off of him. And that guy's probably going to prison. Johansson should use ham radio. Oh, yeah. But anyway, whew. Yeah, someone at the SEC got a boner when this happened. Well, this is not all he's facing. And if you guys remember when we talked about Logan Paul's stuff way back, there are multiple entities involved in regarding trading of commodities and things like that. And it's called the CFTC, the Commodities and Futures Trading Commission. They are their own investigative agency. So not only is it the SEC, the Federal Trade Commission, these guys have their own regulation abilities. So they've charged him with insider trading as well. They've done their own things to him. So there's a lot going on here. And they all operate through the U.S. Attorney's Office. So they're seeking restitution and penalties for this. So it's no different than the SEC getting involved. And they talk about a parallel criminal action. They can prosecute him for mainly civil things. But this operates all in conjunction with each other. Yes, Mr. Tim Beatty, it's insider soft trading. Yes. So it is very, very funny. It is very funny. Gunnar Damus says this guy gets a pardon. I don't think so. I don't think so. I don't think so at all, but it's very interesting to see how this is set up. All right, guys, sorry. Had a little back there. The issue isn't the gain, no. Well, for Polymarket and the SEC and the CFTC, it is. For the U.S. government, it's to use the information. The other stuff is secondary. They're more pissed off he used that information for personal gain. So, but yeah, that's a lot to... that's not a lot of money to lose your life over, because this guy's life's over it now. You know, this guy had 15 years in the military. Like, he was almost to 20. And he did this for like 400 grand. Like, it's so stupid. So stupid. But he got greedy and he got caught. Remember, chat, pigs get fat, hogs get slaughtered. Oh. Clendy Whittle says, I don't think he broke any laws. Well, he did. He took advantage of like classified military operations and started making bets. Does that necessarily meet the same spirit of it? No, but you can't use that information for pecuniary gain. Now, yes, normally the idea of using it for personal gain is I go like, I go up to the Chinese embassy and go, like, hello, would you like information about U.S. battle plans? And they would go, hello. Yes, I would like those very much. Very premium. And I would give them the plans for Operation Absolute Resolve. This is a little different. But this is, yeah, he broke a lot of laws, but maybe you could argue he necessarily didn't break the personal gain one, but I don't think so. Tim says he's an SF. It doesn't sound like it. It sounds like he only got assigned there in 2023, so that means he probably wasn't SF. He was just attached. There are a lot of support units for every ODA that's out there doing business and putting in work somewhere. There's a ton of support elements for them that run around helping them that are attached to that Special Forces group. Oh, Eric, you're saying, no, this guy was a Green Beret? Ooh. Oh, so he was on it. So he went out there at, like, I will give him credit then. It's very impressive that he bet on himself. I'm going in, I'm going to go put in some work, and I'm going to get back out and make money off it. That's actually kind of based. That's kind of based. That's like betting on yourself. It's like Pete Rose. Pete Rose bet on himself to win. But at some point here, I can see in the future, people are going to start, like, point shaving. Like, how many people are we going to capture or kill? It's some guy's out on the raid, and he's like, oh, I'm going to let him live. And then I'm going to go back and collect on the Polymarket bet. Yes, he's trading. Eric says, yes, no, JSOC Hall of Fame for him. Well, I mean, it's like, look, there were dudes in the 7 Special Forces group running drugs. This is like not as bad. Yes, when is self-confidence a crime? Yes. He's a SOCOM Pete Rose minus the minor misconduct. Yeah, well, there's no him running over a guy at the All-Star game and fucking him up. Wait, Trump made a Pete Rose comment about this today? I didn't hear him today. I was busy. Pete Rose lost games just for money. No, I don't think that was ever proven. I think, he made bets on games he was in, but I don't think it was ever proven he took a dive. Nick Rekieta said I could bet on my own black operations. Well, Nick only heard the word black, and he was like, yes! This guy's call sign was Charlie Hustle. Oh, Trump called him Pete Rose? That's fucking hilarious. That is fucking hilarious. Oh, my God. I didn't know that. But see, me and Donnie, we think together, man. Oh my God, he might pardon this guy. Oh my God. He really did say this. Holy shit. All right, Chet, here we go.
A special forces soldier who was involved in the capture of Venezuelan President Maduro, who was arrested by federal authorities today on suspicion of insider trading and betting on Polymarket. Are you concerned that federal employees are betting on these prediction markets and potentially getting rich?
Well, I don't know about it, but was he betting that they would get him or they wouldn't get him?
It sounds like he was betting on his removal from office, that Maduro would be removed.
Well, that's
it sounds
interesting.
like he was involved in the operation.
That's like Pete Rose betting on his own team. It's a little like Pete Rose. Pete Rose, they kept him out of the Hall of Fame because he bet on his own team. Now, if he bet against his team, that would be no good, but he bet on his own team.
I mean, I think he might get away with this then. That's fucking hilarious. That is fucking hilarious then. I didn't know that, chat. Thank you for pointing that out, EDW. Thank you for pointing that out to me, man. He's going to get a pardon depending on what the bet was, yeah. Based. But still, I don't like there are problems with that. We don't want members of the military profiting off their information. I think there was an allegation when the Iran stuff kicked off. There was like somebody walked away with $200,000 as well. So, yeah. I swear the only way to get Trump info is through a press conference or a text message, yeah. The Trump sent him a copy of Art of the Deal. Yeah. Look at the look on Trump's face. He knows exactly. Well, sure, that's what he does. Clyde is a PJ. He would never bet. Oh, yes. He would. Clyde, if Clyde could be yeah. Because he's a good boy. He'd come over and comfort people. Huh. Taking advantage of gamblers is also based. Oh. I bet Clyde has bet on CENTCOM black operations. I can't tell you, but Clyde's made a lot of weird bets at 5 a.m. before. And yes, we don't want guys out on the line getting the spoils of war. That is kind of funny. Even the Navy SEALs wouldn't leave Clyde behind. They know better. They know better. There are no repeats of Roberts Ridge if Clyde's involved. No repeats of Roberts Ridge if Clyde is involved. That's interesting. Whoa. I didn't realize that guy was full-on operator, but yeah. It's like a whole ODA starts like betting on their operations. That would be so funny. Yes, the Navy SEALs, yes, they basically they abandoned Sonny, more or less. So, all right, guys, that's what I thought. I thought it was funny though with the whole idea it's SOCOM insider trading. So, if you guys didn't know about it, that's yeah. There you go. All right, moving on. The update on something we saw before. This is Judge Rosie Speeding Gonzalez. We talked about her before. She is a judge. So it's shocker. She's proud about being LGBT. QIA plus 2P. Blah 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 blah. She was indicted for arresting a local attorney over a disagreement in court. And yes, she looks gay. Yes, of course she is. And from here, we know what happened. There's been some more stuff that's been released. And I think this is actually very interesting, guys. This came out after we had talked about it last. There was a bit of a disclosure about what happened here, and the story does kind of fill us in.
Gonzalez was just arrested this week following an indictment. Our Alicia Nieves has obtained the court transcript and breaks down what
Elizabeth Russell then
Here we go,
failed
chat.
to hearing. A defendant accused of violating probation.
released transcript shows how quickly it escalated.
So here's how crazy this judge got.
Began as a routine probation hearing. A defendant accused of violating probation admitted he failed to check in.
People violating probation, a very common thing. It happens, whether you fail to check in, you fail to show up for a drug test, any number of things.
And with his probation officer. His attorney, Elizabeth Russell, then asked to correct the record. According to the court transcript, that request triggered a heated exchange with the judge, Rosie Speedling Gonzalez. Attorneys are not allowed to coach answers to their clients, the judge said. As Russell objected to how the record was being described, Judge Speedling Gonzalez warned the discussion was over.
I don't like how they do that whole ethnically saying the names. Just speedily, like, I can't roll my L's and R's. I'm in trouble in Florida. I got to learn how to do that.
Saying, quote, "Your argumentative ways are not going to work today. Stop or I'll hold you in contempt." The back and forth continued with the judge asserting control of the courtroom. Moments later, the transcript shows Judge Speedling Gonzalez directing the bailiff to detain the attorney, saying, "Put her in the box." Just 8 minutes into...
That means the jury box, chat. That's normally where, like, if the judge wants to make like a defendant sit there and sweat for a minute, you sit in the jury box. Or a lot of times if they do a docket where it's a cattle call and they bring in a bunch of guys in custody, they get brought into the jury box and then they're called up.
The hearing, Russell was placed in handcuffs. The transcript shows she repeatedly asked for a contempt hearing and for a judicial supervisor to be contacted.
Which is true. If you're being held in criminal contempt, you can't hold her in contempt without a hearing. And the judge would have to be recused from that hearing, just like what happened with Brian Steele, because now that judge is a witness to it.
Judge responded, "I can hold you in contempt, Miss Russell. Are you going to behave professionally or aren't you?" After Russell replied, "I will," the judge ordered the handcuffs removed. But the confrontation didn't end there. The transcript shows continued accusations, claims of bias, and threats of grievances from both sides before the judge moved to end the hearing early. Now, more than a year later, a grand jury indicted Speedling Gonzalez on charges of unlawful restraint and official oppression, accusing her of illegally detaining the attorney while acting in her official role.
Which she did. Now, what happened from here? This is actually bullshit what they allowed here. So,
new details tonight show...
I hate. So, she's being allowed to resign, which is absolute shit. So, a judge indicted is giving up the gavel and resigning. The judge is indicted on charges of official oppression. In early February, she was suspended by the Texas Judicial Commission and faced discipline pending the outcome of her case. But in recent days, she and the commission came to an agreement she would voluntarily resign in order to avoid further discipline. It stipulates she is forever disqualified from working as a judge in Texas, lest she face more legal trouble. Absolute horseshit. She, yeah, this shouldn't happen. Shouldn't happen like that. Meanwhile, her attorney filed a motion to dismiss the indictment, and the prosecutors agreed to it, and it's just absolute garbage. But, this was over a 10-minute issue over a verbal disagreement about the transcript and correcting the record. The judge was questioning the defendant about accusations he violated his release when the attorney conferred with him. And after the lawyer did so a second time, that the judge said, "You can't coach answers." And and here's the thing. The judge said the initial response would be on the record, but the court would recognize that the later allegation, in fact, later said the allegation wasn't true. You know, this is, yeah. It's a big boy club and you're not in it, Sean. Oh, I know. And then later the judge asked him if it was true he didn't complete his court-mandated community service. And he said, not true. So the judge said, state you have a true plea for a violation to that number 4, and then stated not true after being coached by his attorney. And then at that point, that's when things got all fired up. And this is just disgusting. You know, and she got to stipulate the deal does not amount to an admission of guilt. Oh. Marlene says, talking to the defendant coaching answers. Well, at times you might be coaching answers. When it comes to probation violations, this is where a lot of times with a lot of clients, and this is something I've noticed in the 12 years I've been doing this, they think they complied with X, Y, or Z. And you have to explain them, but you didn't. And they're very adamant. They're like, no, but I did. And I'm like, okay, what did you do? And they walk you through it, and you have to explain to them, okay, I understand you think that's compliance, but the judge was asking you for X. And it's really frustrating because usually I sit down and explain, here's what you have to do, buddy. We need to get it done. And they still don't fucking do it. So there are times where you have to explain to them what's meant. Now, is that coaching them? No, it's making sure, do you understand what she's asking you? But no, there are ways you could coach a witness, coach your client, but yeah, you can't be doing that. But it doesn't sound like she was coaching him. It just sounds like she was making sure to do the right thing there or say what they meant. Well, anyways, that's a very good question, Marlene. Thank you. So let's see here. What else we got? That's a very good question, though. Barton Bella says Vicodin is such a better high than Darvocet. I'll take your word on that. Terabus, when I hurt my knee, I still have like a whole bottle. They gave me like I was really kind of surprised, especially like as I got out of anesthesia and everything, and 2.0 had me home, and like I had this big old freaking bottle of I think they're Percocets or Vicodins, and I'm like, I didn't think they did that anymore, but I have like a whole fucking bottle of them still. Terabus says, can the coroner tell if it's pre or post cutting off fingers? I mean, there's probably times you can tell, but there's going to be times, especially the body is decomposed. Like when a body sits in a trunk all summer, it turns into it bloats, and then all the fluid collects in the bottom, and then eventually it kind of leaks out. So that trunk of that car is just full of goop and things, and the skin is kind of like starting to mummify a little bit. I don't know if they can tell when they came off. I mean, it all depends. It all depends. But generally, if you're just staring at you're just staring at some nubs, I don't think you can necessarily tell if it was a post-mortem or not. It's a very good question. That's a V2 enthusiast. Okay. OSIT Commando says for 15 months, says Mary Jane is going to be Schedule 3 and not Schedule 1 score. Yep. Yes, it is, but it's not going to change everything for us. It's still not decriminalized federally. Coffee Cat for $10. Thank you. Says happy belated 420. Yes. Happy birthday to the great Austrian painter. And also, if you are an aficionado and a Columbine reenactor, oh boy, you had a fun day. If you love Hitler, school shootings, and Jesus, a couple of years ago, especially was on Easter, it's like, today's your day. But instead, this year is just if you like Hitler, weed, and school shootings, like, oh yeah, today's a good day. 2 scoops of Destroyer has been a member for 42 months. good to see you, man. Hope you're doing well. Hope you're doing well. Says go big or go home, I guess. Yeah, I guess. He went a little too big. VTubing enthusiast for $5 says, the two cans can't just have a brother make an honest buck in this country. Free Cannon Ken Van Dyke, arrested because he was a good capitalist. Thank you. Objective Gestalt for $5 says the hairstyle tells me she should be able to pivot to a career in the auto repair and or carpentry. Yes, or welding. Or general welding. Thank you. The Zakusa says Nerdrotic Gary won a bid for a chair from the Starfleet Academy set. Oh, I'm sure Gary was like hoping. I think he thought that was a joke, and now it's backfired. If those of you who are in Gary's chat all the time, he now has to do shows sitting in that chair. Make him suffer. Make him suffer. That would be funny. That would be funny. Viking is gay. Percocets for real men. Yes. Oh, he loves it? Oh, okay. He asked for it. Well, there you go. Yeah, that's the thing. Like, when you die, yeah, if you're found, like, just rotting away, they could take you out in a bucket after a while. Yep. Very true. Very true. I take it good says an antidepressant and Uzi enjoyer. And then Creech says cocaine has legit medical use. Yes, it's a topical analgesic. It does have some. I mean, it's a number. It'll numb things. It has analgesic properties. There is medical grade cocaine. It's not as common now, but they still do it once in a while. But for a long time, yeah, it had a ability as a analgesic. Just like Novocaine or something like that. It had capabilities, and it was used. And so. They probably gave me Norco, which is 5 of Oxy and Tylenol. That's what I got when I had autographed ACL reconstruction. I'll have to go take a look. I'll take a look after. When we go to locals, I'll go in the bathroom and try to find them. But I don't think I had Norco. I'm pretty. Hold on. .2.0 says they're Percocets. And because she had to organize some things while we're getting ready to move. So she's like digging through the pile of pills. And it's like, oh, fucking tube of Percocets still. So, but no, that's when I tore my patella tendon. I only took the pills for like a day. And then I took a lot of ibuprofen after that. And that did enough. You should go in the bathroom and come back without pants. Noise. Well, they give me prednisone for my hand surgery. I had no side effects. Wow. Yes, they numb people for sinus shots as well. Yes. Percocet and Vyvanse. That's an interesting combination. I don't know if that's necessarily the way they want you to do it. Bob Johnson said they've injected. Yeah, they would inject it as part of birthing. Yes. Yes. Ophthalmologists will use it often in eye drops. Yep, I have heard of that before. My addict arc begins. I'll be all right. I'm already addicted to cheeseburgers, so don't worry. Did you see Helen Keller's 1-of-1 autograph card just sold for $3,500 on eBay? It doesn't matter. Helen Keller was all fake. It's just really ironic that her Anne Sullivan, who ended up marrying a diehard communist, was around when Helen Keller started espousing like fucking hardcore communism. Isn't that kind of ironic? So. Oh. Wait, they cut out the middle 1/3 of your patella and make it your ACL? Then what do they do with your patella? Because without a patella tendon, you fall over. Trust me, I know. after I tore it, I tried to like stand up once and I immediately like fell down. Because I wasn't paying attention and didn't have my leg in a brace. So yeah, that would suck. Let me see here. What else we caught up to? Helen Keller was working a gimmick, brother. Yeah, it was all a work. Was that the Helen Keller rookie card? Oh. Norco sucks rods. Norco's been fine for me. I'm not one of those people that's ever had all those problems. I know there's some people like, I know some people are like, oh my God, if they give me morphine, like I start like fucking breaking out in hives and shit or like hallucinating. And it's like, that's got to be a rough way to live where you can only have certain opioids or like you can only have like Versed or Dilaudid. You can only have like the premium shit. And it's like, fuck, man, that sucks. Yeah, Anne was working a gimmick. Helen was just derp. Oh, yeah. Oh, yeah. I had the jelly legs. Well, I did. Without the patella tendon, you have no stabilization, man. And I fell over. Yeah, it panicked me because like you had like nothing stopped me. And I fell down and I was like, oh my God, what the fuck happened? And you put on the knee brace and you could stand back up because it like solidifies it. So I have a patellar strip ACL since 1993. Holding strong. Huh. Yeah. Timber. It basically was timber. So. Mine Eggers says, I'm immune to anesthesia, even fent. So how do they have surgery on you? Do you just have to like lie there, like they just paralyze you? And you're just like, ah, like stop cutting me. How does that work? Oh, they take a strip out of the middle of your patella. Oh, ew. Oh, well, they fucked my patella once. I'm good. All right, guys. I think we are on to the last two things here. And something in the story that never ends, the Karen Reed saga. Not only is Karen Reed being sued for wrongful death by John O'Keefe's family after she got acquitted in her second trial, not only is Turtle Boy facing charges for witness intimidation, and that case is dragging on. The Jennifer McCabe, Brian Albert, Colin Albert, and Brian Higgins. And remember, these are the people who likely did murder John O'Keefe, including Brian Higgins, who was, trying to get a whiff of Karen's puss this whole time. Brian Albert, the guy who owned the house. Colin Albert, the son of the guy who owned the house. And then Jennifer McCabe, who did House Long to Die in the Cold. Well, they're suing Karen Reed and Aiden. And they claim this is a multi-year conspiracy by Karen Reed and Turtle Boy to subvert and prejudice the criminal justice process in Norfolk County, Massachusetts. So what did they do? Well, they defamed, harassed, and tormented the plaintiffs. And they served as the witnesses for the John O'Keefe prosecution and Karen Reed for his murder. But it's funny because Karen Reed got acquitted. So it's like, uh-oh. But here's the problem. Yes, they accuse, Jennifer McCabe, Brian Albert, Colin Albert, and Brian Higgins have been accused of covering it up and that they did murder him. Well, they claim that they've been entirely innocent of any involvement. Well, now you're going to have to prove that. You're basically going to have to prove that because guess what? Karen Reed was proven not guilty. And all that evidence is coming in. And I don't think you would even meet a preponderance of the evidence standard against Karen Reed with all that evidence. So they point out that these were calculated operations to assassinate the character and reputation of the plaintiffs. Of course it was. While the damage of the plaintiffs has been catastrophic, Karen Reed and Turtle Boy's lies have also caused a rupture within the Canton, Massachusetts community. Oh, I think the actions of the police department and the Norfolk County District Attorney's Office and Judge Bev Cannoni did a far bigger way of fucking the community up than Karen Reed. Because remember, the cops fucking lied. The Massachusetts State Police lied. How many members of the Massachusetts State Police now have been disciplined and or fired? Remember, we saw all that. Trooper Bukaki. He is now just working a beat. He's been seen in plain clothes working at parades, and people have been making fun of him and mocking him for it because these guys torched their careers. And we found out it wasn't just those cases. It was other cases. The Sandra Birchmore case, the case with Brian Walshy, and then, the Miles King case where we saw that, where they had been withholding all kinds of evidence. All kinds of evidence. Why? Why? These are also the same people who destroyed all their cell phones, and they gave their dog away. They took her somewhere in Vermont, but they don't remember where they gave the dog away to. So this idea that they want to sue people, they're going to have more investigation into them than the police did. And when they get up on the stand to have to testify or in a deposition, no one's coming to save them. They're going to have to answer every goddamn question in the world. I don't know why you would do this, because now you're basically going to have to prove I didn't commit the murder. This literally makes no sense why they did it. This makes no sense why they did this. But they want to hold Karen Reed and Turtle Boy accountable. They claim that social media and other amplification means achieved maximum penetration of those lies. And they enrich themselves through their celebrity. Well, I mean, have they? I mean, they kind of made money, but these people are broke and destitute now. Karen Reed's going to die a poor woman at the end of the day. And they talk about venue is appropriate because one party in this case, Brian Higgins, lives in Barnstable County. Or is it Barnstable? I don't know. Karen Reed is a resident of North Dayton, Massachusetts. And they claim that on January 29th, that intoxicated Reed struck O'Keefe with the back of her Lexus. That was never proven. That was never proven at all. John O'Keefe, remember, had no injury. And this is the one thing when you want to troll the Karen Reed, anti-Karen Reed people. Why does John O'Keefe have no injuries on any part of his arm? His entire arm. His entire arm, chat. No injuries on it. No defects on his arm at all. No broken fingers, no broken bones, no bruises, nothing. So how did he get hit? It doesn't make sense. It doesn't make sense. Yes, get out the blue paint. They point out on June 9th, Karen Reed was arrested after being indicted on second-degree murder. On July 1st, 2024, the jury failed to reach a unanimous verdict. In the 2025 mistrial, the jury convicted Karen Reed of DUI, but dismissed on conclude the Commonwealth failed to prove beyond a reasonable doubt on the remaining charges, which means she was acquitted. And then he talks about Turtle Boy. He's a resident of Holden, named after William Holden. Are you holding on me? Holding out? Are you bogarting? But anyways, goes through all of this here. We may read this at another point, but these people are fucking pudwax. Now there's more investigation on you, and it's not going to turn out the way you want. It's not going to turn out the way you want, chat. It's not going to turn out the way you want. I wouldn't do this if I were them, but hey, they're smarter than me, I guess. They're smarter than me at the end of the day. All right, now we're going to end the night on this. This is a case of God-tier identity theft. Get a load of this. This guy, listen to this victim. Listen to this victim, chat. So first, and we're going to go through some names here. Okay. This is the 8th Circuit. Okay. So here we go. This is like out in Kansas in the plains. A guy known as Matthew David Kierans, also known as William Donald Woods, also known as William D. Woods. He's appealing his case out of Iowa. Okay. It was submitted March 16th. And then it was filed on the 23rd of April. Meaning it took them less than a month to come to the conclusion on this. This guy got nuked so fast. Here we go. They say, and the circuit judge, the judge here starts off. It says, by all appearances, a man who went by the name William Woods had turned his life around. 3 decades ago, he was homeless and worked a hot dog cart. But then the guy got married, had a child. He opened up bank accounts, received credit cards, worked at a hospital where he became the key administrator of critical systems and earned more than $100,000 a year. Sounds pretty good so far. There was just one problem. Although William Woods is a real person, the man is not that person. Instead, the guy's name is Matthew Kierans. Kierans met the real Woods in the 1980s. Woods was Kieran's co-worker at the hot dog cart. From then on, Kierans used Woods' identity in virtually every aspect of his life. Got employment, insurance, social security card, driver's license, titles, loans, and credit using Woods' identity. Kieran paid taxes under the identity. When Kieran stole a car, authorities issued an arrest warrant in Woods' name. And when Kieran stole another car, authorities arrested and booked him under Woods' name. Although Kieran's got married, his wife did not know his real name. Their child bore Woods' surname. Kieran's obtained his job at the hospital with fictitious documents, all in Woods' name. Well, and guys, remember, you could do all this back in the day. While employed at the hospital, he continued obtaining credit union loans using the guy's actual social security number and date of birth. And then Woods intervened. And here's where it gets fucked, guys. In 2019, Woods, who was homeless and transient, entered a bank and told the branch manager that someone using his identity had obtained lines of credit and accumulated a lot of debt. Woods provided his social security card, whose number matched the social security number associated with the fraudulent accounts. However, upon reviewing the information, the branch manager noted the address with the account was not a California address, but a Wisconsin address. Matthew Kieran's address. I think you guys have an idea on where this is going to go. And when the branch manager asked Woods several questions for the security questions, he was unable to answer them. Concerned, the manager called the telephone number. Kieran's answered. Kieran said no one in California should have access to the bank accounts. Kieran's gave the security questions, and therefore the branch manager called the police. The cops spoke with Kieran's over the phone, who told them he didn't give anyone in California access to his bank accounts. Kieran then sent all of his stuff, the social security card, driver's license, and birth certificate. And it ended up being Woods, the actual Woods, got arrested for identity theft. Kieran's told the cops he wanted to prosecute Woods. The police set the case on, and he was charged with felony identity theft and false impersonation. Throughout the court proceedings, Woods insisted his name was William Woods, not Matthew Kieran's. After Woods' public defender and an evaluating physician expressed concerns about his competency, think about that. They're sitting there arguing like, no, my name is William Woods. And they're like, no, you're Mr. Kieran's. Like, think about it. Like, you'd be like, holy shit, this guy's crazy. That would make you want to go crazy. The state court determined this guy was not mentally competent to stand trial and ordered he be placed in a mental hospital. Remember, I've told you guys before, mental hospitals are insane. They're awful. You don't want to go there. And he had to receive psychotropic medication forcibly. In 2021, Woods was convicted of a felony. The state court sentenced him to time served and say Woods had to use his real name, Matthew Kieran's. Think about that. That would drive you insane. He spent 428 days in jail and 147 days in a mental hospital. I'd fucking kill somebody at that point. After release, Woods kept trying to get his identity. Kieran's kept on telling the cops he was William Woods and that Woods was himself. In 2023, Woods contacted the hospital where Kieran's worked and informed the security department Kieran's had stolen his identity. A hospital referred the complaint to the local law enforcement, which sent an experienced detective to investigate. Gradually, they unraveled it. Using DNA evidence, they proved that it was Woods, not Kieran's, was the true William Woods. In 2023, Kieran's was confronted. He admitted he'd been using Woods' identity for decades and produced all the documents. And lied to the cops. So this guy pled guilty to making a false statement to a National Credit Union Administration insured institution, aggravated identity theft, and the district court came up with a sentencing guidelines range of 12 to 18 months imprisonment, followed by a mandatory 24 months of imprisonment. So you're like, oh, wait, that's all this guy's going to face after putting a dude in prison? Is like 3.5 years? That's all? Well, wait, don't worry. this guy actually gets hammered. After considering all the factors, the district court varied its sentencing upwards and gave a sentence of 144 months imprisonment. 144 months imprisonment, chat. You love to see it. You love to see it, chat. That's not enough, I would argue. That's just a start. That's just a start. That's just a start. I mean, 12 years isn't bad. 12 years isn't bad. But yeah. Yeah. So when it did the sentence, the district court emphasized the unique, unusual, and egregious nature. The district court used identity to evade prosecution for crimes. He intentionally sought the prosecution and incarceration of Woods, he put an innocent man in prison. And, it says the defendant repeatedly lied and he hasn't fully reflected in the guidelines. And he still seems to have not recognized what he's done or apologized directly to that guy. Sorry, man, for putting you in a fucking mental hospital for 6 months. Yes. 12 years of felted, yes. So there's special conditions he has to do. His wife at the time claims he had reported a history of suicide. The district court ordered him to participate in a mental health evaluation and complete recommended treatment. And this guy had a history of substance abuse. So he filed this appeal arguing the district court imposed an unreasonable term of imprisonment. It improperly based the conditions on release from conduct from long ago. Notice, we affirm, guys, this is 7 pages. This is 7 pages. This is them telling him to fuck off. So he challenges the reasonableness of the 144 months. Well, they go to a abuse of discretion standard, which is deferential. Here, you can only, if there's a clear error of judgment, is the standard at this point. They say first, the district court committed a clear error by giving little weight to statements that relate his descriptions of his childhood. Well, he said it was tough as a kid. It's hard to believe that anything this guy has said. This guy says when imposing the mental health things, the court credited the affidavit as evidence of his history of attempted suicide. Therefore, the court should have credited the affidavit about his background warrants a lesser sentence. But this inconsistency in how the district court treated it is not a clear error of judgment. The court relied on statements in the PSI about his history of suicide. Other people reported it. They didn't trust him. Secondly, the district court overstated the harm his offenses caused. He put an innocent guy in fucking jail repeatedly. And there's no clear error. Courts have wide latitude to weigh the factors in assigning great weight to those. As the district court emphasized, this is unusual and egregious. And this guy manipulated the criminal justice system to prosecute an innocent man. And Woods would have not been in a position where he would have been subject to being institutionalized, but for Kieran's insistence the guy get prosecuted. Remember, if he hadn't pushed the issue, this guy wouldn't have been in jail. This guy wouldn't have been forcibly medicated. And getting forcibly medicated, that can fuck you up. The guy had no problems. I guarantee you that guy's got mental health issues now. He's also challenging the special release terms. Courts like, we don't care. We don't care. Courts have wide discretion imposing conditions of supervised release. And they say, ultimately, here the mental health and substance abuse conditions satisfy the requirements. And they don't care. Nobody cares here. Nobody cares here. And they point out that throughout the interim 3 decades, this guy pretended to be someone else. He hid his identity from his life and gave his child his victim's surname. In light of this behavior, yes, getting substance abuse and mental health is important. Further, the history of deceit undercuts the credibility of his assertions. He no longer struggles with mental health. And they're like, we don't care. The district court did not abuse its discretion in imposing special conditions of release. Therefore, we affirm. And they're just like, fuck you, done. Oof. Yeah. There you go, chat. That is a complete ownage. And honestly, finally, a identity thief got what he deserved. So I hope that makes you feel better. It gives you a little bit of a white pill tonight, chat. The guy got what he deserved. Got what he deserved. So with that said, guys, we are going to wrap this up here. Thank you all for being here. We're all done. Let's see what we got here. Oh, Chugi Show. For $5 says, Sean, you can't talk about medications. You should read the statute of practicing medicine without a license. I know. Although, hey, it says in my degree, it says doctor on part of it. So I can talk about it. Actually. Oh. So, all right, guys, we are going to head over to potentiallycriminal.locals.com. Promo code IceStorm gives you 1 month free access. We're going to go hang out there, guys. Sell stuff we can't do here. Join us over there. It's a lot of fun. And before we get too far, once again, guys, dragonstreasure.com, 10% off the code criminal or 15% off the code Jubal. Help out the tea, man. Buy some tea. Make the quartering suffer. Buy quality tea. You know, T-Man doesn't bullshit you about his coffee. Don't buy Cuck brand coffee. Buy T-Man coffee. He's based. He doesn't put up with cucks. Minnesota or Wisconsin. Buy his tea, chat. Buy his tea. Show the T-Man some love. You made $1,000 on Intel today. Cool. Bull brand coffee, yes. Take the CLE, Sean. Use a code Kirsha. Does she have a code with Dragon's Treasure? I mean, I don't know. Bob says your look and facial movements remind me of Anthony Stein, who runs the Return to Tradition Catholic channel. I don't know if that's good or bad, because I don't know who that is. But it must be based. It must be based. Yes, mean copium and his sand-based coffee. Who wants sandy coffee? Who would want that? So, anyways, guys, with that said, I will see you guys tomorrow. We are going to go through some stuff. We are getting into Smash JT. And if you guys want a lesson of what it's like to see a guy run through a fucking minefield at full speed and step on everything sticking out of the ground, we're going to do it tomorrow night. Tomorrow night, chat. It's going to be fun. Start about 7:30 because I want to get done because I'm actually, we're going to keep working on our model. Because now we're getting to the point of, with the elephant chat, we're ready to prime it with red primer and actually get battle paint on it. We're getting it painted, chat. We're going to do chipping tomorrow while we watch the casino. So there we go. Young and Bitter, how you doing? Good to see you. Yeah, that guy would have been, it's normal to stick people in a mental institution if they think they're someone else. And give him a shot of like Haldol or something. Imagine what that guy's been through. But yeah, we're going to cover Smash JT and what not to do in a lawsuit. Yeah, it's an instructive tale. Chat. So I will see you guys tomorrow. And remember, until next time, chat, just because you did it does not mean you're guilty. Although, be careful with your polymarket trading, chat. Come on now. Be careful. Good night, chat. And take care.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops. Even when they nab you on illegal stops. Just cause you did it doesn't mean you're guilty. But please talk to